For the court this morning is the case entitled Jeffrey Rivard versus Windham State Attorney and Dana John Nevin, case number 25 AP 152. Appellant Jeffrey Rivard is self-represented. Representing the appellee, Windham State Attorney and Dana John Nevins, is Attorney David Boyd.
Mr. Rivard, do you understand you have 5 minutes and I can give you a warning when 4 minutes are up? Oh, I can't get your audio. I think you might be.
I thought I had 10, but 5 is sufficient.
Okay, so I'll give you a warning at 4 minutes, and then you'll have 1 minute after that. And also that the Chief Justice does not have video. He will participate in the case, but he's participating with audio only. So he might ask some questions.
Thank you, Justice Cohen. Thank you.
And one last thing is that we had some problems with our WebEx platform yesterday. I think all the issues have been resolved, but if for some reason we get cut off or unable to do this, we'll just reconvene immediately thereafter. But we think hopefully that it's all worked out and this should be fine. So Mr. Rivard, could you just identify yourself and you may begin your argument.
Yeah, if it may please the court, I am Jeffrey Rivard. My argument is from the lower court in Windham on dismissal grant or claim preclusion. Basically, the court refused to or declined to address immunity, and I'm going to address it anyway because of the overarching sort of complaint here. The state can't transform a procedural denial to leave to amend into a merits decision, especially when the Superior Court never evaluated the substance of the proposed defamation claim. I filed a timely motion to amend under VRCP 15A. I moved promptly to add a defamation count once the facts solidified. That motion was before Judge Barra on the declaratory judgment claim, but he never addressed the legal or factual sufficiency of those allegations. Denial of leave to amend is discretionary, non-preclusionary. Vermont law treats refusals to grant leave to amend as discretionary case management rulings, not merits adjudications. In Lillycrop v. Martin, 1989, this court held that denying an amendment does not resolve the merits of the pleading. Federal courts uniformly agree. A denial of leave to amend is not a final judgment on the merits under Bowman v. Davis, 1962. Judge Barrett's conclusion underscores lack of merits analysis at oral argument below. Judge Barrett admitted he was not clear what relief we sought. I argued parental rights from a conditions of release that was much prolonged in another case, causing a loss of social with my family and household. We moved solely for declaratory relief regarding parental rights, prolonged no contact, nearly 2 years and 10 months. And the court never evaluated these claims or even rejected the defamation allegation. Because we sought amendment and no court reached the heart of the defamation theory, there was no final judgment. Under restatement second of torts 18D, which I'm using anew, it sort of shows that the judge was fundamentally wrong, or an error was made. And this is supported by Brennan v. Clean Cut Manufacturing. Res judicata plainly does not apply. In terms of absolute immunity, Imbler v. Packman supports that this is not a court judicial function for the prosecutor in that capacity. And so even without a dismissal, with prejudice, it was just dismissed. The fundamental concept is that absolute immunity wasn't asserted. It doesn't apply. He made a representation of violation of Rule 8.4. And basically I yield my time.
Thank you, Mr. Rivard. And Mr. Boyd, you identify yourself and identify your client, please.
Good morning, David Boyd on behalf of the appellees. Mr. Rivard previously sued the appellees in 2023. I'm sorry, am I still here?
You are, yes.
Okay, I just lost the video
Can you
feed
not
there.
hear us?
I can hear, I've lost the
I
video
think
feed,
just
which
as- I can see and hear you. Can we just
Okay.
stop the time here, please, Bailiff? And
I can hear him.
The time has stopped.
thank you. Mr. Boyd, can you not hear us?
I can now hear and see. The video is a little laggy, but I can hear fine. And so it can
Okay,
continue.
your video to me is fine. I haven't seen any glitches at all or any still photos. So I've heard everything you said, but we can start your argument again with your 5 minutes.
Thank you.
Okay.
Mr. Rivard previously sued appellees in 2023 on the theory that they engaged in a malicious prosecution of him and made false statements in an October 2022 Brattleboro Reformer article. That case was dismissed on the basis of prosecutorial immunity and because it failed to state a claim upon which relief could be granted. And the ruling below should be affirmed because the court correctly found that claim preclusion bars Mr. Rivard from suing appellees again now, based on the same prosecution or statements. The question is not what claims Mr. Rivard brought. It is whether this case arises out of the same transaction or occurrence. It does. It arises out of the same prosecution and the same statements, and therefore claim preclusion applies. Mr. Rivard's claims are also independently barred by absolute immunity as to the state's attorney and by qualified immunity as to the Deputy State's Attorney Nevins for the same reasons they were barred in 2023. And the supplemental submission Mr. Rivard provided recently does not change the analysis. The focus of the supplemental submission is on Section 18, Subpart D of the Restatement of Judgments. Section 18 of the Restatement does not have a Subpart D. To the extent it's a reference to Comment D, that comment deals with the effect of a judgment rendered in another state under the Full Faith and Credit Clause, which is not relevant here because this case does not involve an out-of-state judgment. And unless the court has any questions, I would yield the remainder of my time. Thank you.
Thank you, Mr. Boyd. Any questions for Mr. Boyd?
No, thank you.
Okay, Bailiff, does Mr. Rivard have additional time?
Appellant has 1 minute and 48 seconds remaining.
Mr. Rivard, you have 1 minute and 48 seconds.
I may have an incorrect restatement of torts. I don't have an original book. I know the judge had used, I want to say 24, which deals with the transactional nexus test, in that the declaratory judgment still wouldn't suffice with the Vermont Supreme Court declined to even hear the defamation merits in that adjudication. So what I have from that in terms of subsection 18 is just maybe incorrect, but it's just built around final judgment on the merits, which I think maybe should be taken as fact. And that's it.
Thank you, Mr. Rivard. Any additional questions for Mr. Rivard?
No, thank you, Justice Cohen.
All right, thanks. Can we call the conclusion of this case, please?
The next hearing for the court